dockets, that is now the Nongoma docket,
Yeah, yeah.
and the other 4 dockets be perused here in court.
Yes, quite.
In fact, the court remarked that they may not be taken home.
Yeah.
However, the defense were of the view that the court order can be interpreted in such a way that that copies can be made of those dockets, and we therefore could not reach
Those are privileged documents, are they not?
an agreement yesterday. Indeed, my lord.
I mean, and if you know your law, those are privileged documents.
Yes.
The state, the accused are not entitled to those documents as a matter of right. If you read State versus Chabalala
Yes.
in the Constitutional Court, it tells you that that is part of what C of the docket.
Well, it's in our view, it's additional information.
Yeah, fine. But the point is,
they are not really.
they are not yet charged
Yes.
in the technical sense.
In
The matter was supposed to be enrolled, and the prosecutor in Post Luras
Yes.
came with a new version of the law that
Yes.
he doesn't have jurisdiction,
Yes.
which is not correct.
Yes.
And the charges were never laid, in other words.
Indeed, the accused
And then, as
never
Mr.
appeared in.
Brigadier says, they decided that they should investigate all those dockets, 4 of them. And thereafter, because they are situated in different parts of the country, they must apply for consolidation.
Indeed, my lord. And
What
again,
section is that? Consolidation.
Centralization
Centralization and consolidation. Mr.
of the charges.
Yes. So you can charge a guy having killed a person in Cape Town, and then he goes to so-called the border of Mozambique and South Africa,
Yes.
and then you consolidate those cases, the cases handled here in Pretoria.
Yes.
Because the Supreme Court is the Supreme Court or the High Court of South Africa. If you read, there's nothing like the High Court of Gauteng. It's the High Court of South Africa with subdivisions in Gauteng, Northwest, Cape, KwaZulu, KwaZulu-Natal, whatever.
Yes.
But it's one court in essence.
Indeed, my lord. And we've already seen in Exhibit B that that there was centralization of the charges in this matter.
Yeah.
And we again this morning listened to the recording, and that's precisely what the court said, my lord. The stance of the state is exactly in line with what the court ordered yesterday.
Yeah, but I made an order that they must be read in court. Is that not so?
Yes, indeed, my lord.
Yeah, so what's the problem? Mr. Ngomezulu, what is the problem with my order?
God praises, my lord. My lord, the defense and the state, after we adjourned 2:30, we went to the office of my colleague, Mr. Baloyi,
Yeah.
with the purpose of obtaining such copies. So it came this morning that there is a dispute regarding that. But yes, the whole of afternoon yesterday, there was no such a dispute. But in relation to, if I can take the court back to the request that we made during the evidence of Mr. Mkhane, Sergeant Mkhane,
Yeah.
the court made an order that we should have access to the docket.
Yes, of course, yeah.
And there
But
was
not copy anything. That's why I said it must happen in this court. Because the last time you remember what happened.
I remember what
Yeah,
happened. my
the
lord.
order was taken and shown to your clients. That's why I said the rider is, it must not even taken to my sitting room.
My lord, all emanated from dockets 163. But now the state is alleging serious allegations against the accused.
Where?
And in terms of State versus Shabalala, he was supposed to disclose such information for a purpose of consultation.
Which one? Which information is that?
I mean, regarding the alleged or pending matter of murder.
In the Nongoma case?
The Nongoma case.
No, State versus Chabalala is not applicable. Please.
That's what was
State versus Chabalala is applicable to a case which is going to be heard at a particular time, where the indictment is drawn and where your clients have pleaded. Then you give, as a matter of constitutional right, in terms of State versus Chabalala, then the state is obliged, they have no choice, to give you all the contents of the dockets which they are going to use, except, of course, classified information.
My Lord,
But this is not applicable to Nongoma. I said I'm making the order in fairness to you because there is a possibility that you may want to glean information which affects the admissibility and otherwise of the confession, and you want to raise certain issues.
but my submission, my Lord, is that when the court remembers, every time the state is disclosing new evidence during the course of the trial, within the trial, was furnishing us with the contents, of which such contents, most of them, were not discovered during the trial. In this case, the issue of 163 started during trial within the trial. So why is the state at this stage reluctant, if during the course of it was, we even call it ambush discover? Why are they not open before this honorable court and give us the content so that we go through?
No, but Mr. Advocate Ngomezulu,
Yes,
the state has been ordered to hand over the dockets to you guys.
yes.
The proviso is that they must be read by you in this court. You can read it to page 1 to page 100, no problem. But you are not allowed to make copies of those.
Court,
That's the order. It's a simple order.
That has not been done.
And I never said you can't make notes, but you can't make copies.
Court, please.
So that is the order.
Njengoba izolo masibisa icala inkantolo yayithe abameli bethu baboniswe namadokodo lawa ekuthukela Gininda ukhuluma ngawo. Manje izolo bekwamele afundwe lawo madokodo kodwa kungayenzwa amakhophi. Manje kunokungazwani phakathi komshushisi nabameli benu, bona ingathi bebafuna ukuthi bathole yonke into, ujaji uthi bona banelungelo yokuthi bangafunda yonke kodwa bangatholi amakhophi okwamanje ngenxa yokuthi lamadokodo awakhuluma ngoNtanzi ukuthi kunamanye amacala ayikuthi mhlawumbe bangagcina sekuthi bamthesa wona. Okwamanje akakathweswa lawo macala, yingakho ukuthi akwamenanga ukuthi kukhishwe amakhophi, kodwa ukufunda nokwenza ama-notes abameli benu banalelo lungelo lokuthi bangabhala ukuthi mhlawumbe nanoma ubrigadier ekhuluma ephana ngokufaka bese bakwazi ukubuza ngalento eyikuthi nabo bayibonile.
And I'm saying this because there's evidence here through Sergeant Bokhano that he doesn't know you, Mr. Ngomezulu, and your attorney. He doesn't know how you acquired that information which is confidential to the police. Do you remember that?
Yes, Exhibit B.
Yeah, you remember. The investigating officer in that matter, he says he doesn't know how you gained access. You are not to blame, your attorney. He doesn't know how your attorney gained access to that confidential information. It was not officially acquired because according to Mokhano, if it was, he has to authorize it. So it's not just a simple thing like.
Ngoba inkantolo ikhulumisa nisakhumbula nyakenye kunelinye iphepha ekuthi liye laphuma nagcina nani senibonile. Ithi inkosi yenkantolo uSergeant Mokhano uye wathi akazi ukuthi ubabu Ramsipili uyithole kanjani lawo maphepha ngaphambi kokuthi azokhishwa nakini, ngoba lawo maphepha lawo bekwamaphepha ekuthi abhalelwe akwamelanga ukuthi abonwe yiwonke umuntu. Yingakho nawo lawa inkosi yenkantolo ithi akwamelanga ukuthi kwenziwe amakhophi azobonwa yiwonke umuntu. Ingakho efuna ukuvikela lamadokodo.
And if you remember, Mokhano said his job and deliberations are governed by the Official Secrets Act. Did he say that? I mean, he said that. That's why I'm making such an order. Remember, there's a...
As the court pleases, my lord, my lord will be given an opportunity to make our submissions also on this issue.
Which one is it now?
This issue of that you are dealing with the copies of dockets.
No, I've made an order, Ms. Mchololo. Dockets will be read in court.
As the court pleases.
What submissions do you want to make? So have you read the dockets?
No, my
How
lord.
long do you need? 3 weeks? 2 months?
We have not yet received them.
Hello?
We have not yet received them.
Yeah, because he says you said you wanted to make copies. Where are the dockets?
They are available, my lord. They are with Brigadier Gininda.
Where's Brigadier Gininda? Hey, yeah.
Namadokodo abakwazama ukubafunda izono njengoba babadala impikiswano kodwa akhona abobrigadier naye angathe wakhipha ukuthi abameli bakwazi ukubafunda.
So how long do you need to read those dockets? Because yesterday you had about two and a half hours. How long do you need?
I think we don't even know how many pages are there and what.
I saw those dockets, they're thin. I was looking at them.
They are thin, madam.
Yeah, thin. Thin. I was looking at them. How long do you take to read 100 pages?
I can't confirm their thickness or their thinness. But I think we need to be at first with the docket because it's not only reading them, it's to read and analyze them at the same time.
If I may
10
say,
minutes break, madam, then we come back to the court and indicate how long can we take to peruse them.
indeed, that was going to be the suggestion that we adjourn for 10 minutes. Then we assess the dockets and see how long.
Where are the dockets? I want to see them.
Yeah.
Because I saw them yesterday.
Yes. They are with the Brigadier Gininda, my lord. He's just parking outside.
It's parking.
Yes, I'm told he's just making his way to court.
Oh, I see.
I think he was delayed on the way. So
Yes, ubrigadier ubekade nento esambambile kodwa uyeza uyangena amajele enkantolo.
we request that we adjourn at least for 10 minutes, my lord.
No, I'll adjourn after he comes. I want to have a look at the thickness. I saw thin dockets.
As a good business.
Inkosi enkantolo ithi izomlinda azafike bese ke kula izothatha isinqumo ukuthi isikhathi esingakanani elimisa ukuthi abameli bakwazi ukubona lawo madokodo.
As soon as he's here, my lord, we'll let the court know. Maybe the court can just wait in the corridor.
Yeah, I'm comfortable if I'm seated here. You should get out and leave me alone if you're uncomfortable. If you need the whole day, you'll get the whole day. But the proviso, as I say, is you read them here in the presence of the prosecutor. Because I remember I once handled a case of a certain police general. He was charged with whatever. Was amongst the charges was allegations of fraud and what have you. And what happened is they just used the Official Secrets Act to classify the documents. I don't know if you were in that group of prosecutors. And the prosecutor decided they can't go on because about that charge because
The documents need to be declassified first.
Yeah, but who says the court can't do it? Because you've got to explain why you classify them. I'm charged with killing a person, then I classify the post-mortem report. That's how nonsensical sometimes the classification is being abused in this country. Are you aware of that?
Yes, possibly.
Somebody just classify
Such instances.
the post-mortem report, and as a result you can't prove why this guy was, what is the reason for his death or her death.
Yes.
It's classified.
Yes. Even the instance that the court alluded to of fraud, I mean, it's nothing secretive about documents that are in the docket. But most probably it relates to tender procedures,
Yes,
procurement procedures, and all those things.
that's it. And those documents were classified. And the joke is, when another head of intelligence was appointed, he immediately declassified those documents, and the charges were reinstated. You remember Sergeant Mukhale said after the disclosure of that document that he now fears for the life of his witnesses.
Indeed, my lord, and that is the main reason why.
Yes, you remember he said, I thought me saying that. He says now I fear for the life of my witnesses.
Yes.
But you see, court officers are court officers before they are attorneys or advocates of their own clients. They take an oath to uphold the law and the constitution of the country. So if the case has not been fully investigated, they know the consequences.
Yes.
And then you have access to the docket. The matter is not fully investigated or finalized, being investigated. But here there are special circumstances which make this court to say they can peruse the docket, because it may be Mr. Gomezulu and others, they want to use the contents of the docket in disproving the allegations against their clients. I don't know.
And indeed, my lord, the state wants to meet the defense halfway, but there's a serious concern that if copies are made of those dockets, that might spell the end of the investigation in those matters. So there's really a serious concern here.
Yeah. But under apartheid, I can tell you, the judges of old, they had so much power, they could ask, why do you want to use the docket, Mr. Gomezulu? And you say, hey. And then the judge reads the docket alone, not with you. Doesn't even make the docket available to you. And then he tells you, I've read the docket, this exigency you are dealing with, I don't think you need this information. There was no accountability then. Then the judge, he makes that ruling. But he doesn't think it's relevant. It's relevant. You can take him on review and appeal, fine.
That's the reason for that doctrine. Sesanto Rationality case at Ipselex.
Mm-hmm.
Yeah. If the reason of the law ceases to exist, the law must fall away.
Mm-hmm.
So on the introduction of the Constitution, that that law had to fall away, not by privilege or by choice.
Yeah, no, I say the law has changed.
That's correct.
Yeah. But when we were practicing, the judge could even determine what evidence should be led in the interests of the security of the state. Hello?
The attorneys back then challenged it because the court once asked me whether I challenged the lawfulness of the arrest of 1 and 2. So that Security Act, did the judge challenge it?
Hey. Yeah, some of us try to challenge all those, but the judge, because the judges had such a wide discretion, they would listen to you and after that make a ruling. But now you are entitled in terms of the Constitution to challenge anything and everything.
Ningamangali madoda angitoliki ngoba inkantolo iyayixoxela nabantu.
Yeah, umlevo lona.
I think the current position is that there must always be a connection between the exercise of power and the rationale for for such exercise
Yeah, right. Yeah.
of power.
That
So
means
there's that balancing
Yeah.
act currently.
the Administrative Act. What's Act 60? What's the section?
Yeah,
There must be a rational basis for the decision which a judge takes, or any person who exercises public power.
yes,
Is that not the law?
yes, indeed.
Yeah, it must be based on rationality. And that was developed after the 1960, is it 60? No, sorry, 1966, the Constitution? The first
1996, yeah.
1996, so the first
Yes.
Constitution.
Yes,
Yeah, administrative law was developed then.
yes.
But before then, it was just difficult.
Indeed, my lord. I wonder if we should not take the adjournment. I wonder what the hold up is.
Okay, let's adjourn. You'll call me.